Hi everyone, this is immigration attorney John Khosravi. Welcome to episode 63 of the Immigration Lawyers Podcast, a professional podcast really meant for other immigration attorneys discussing the news of the day and analyzing some detailed information about recent court cases and other information related to a professional immigration practice. Thank you so much for tuning in. I hope you had a great holiday season. Christmas just about ended and New Year's is coming up, and I hope you have a safe time. Unfortunately, the immigration realm is full of disasters right now, which I'll get into, as well as breaking down some new AAO cases, in particular in the L-1 and EB-1c area, and much more. I look forward to talking about it right after the intro. Welcome to the Immigration Lawyers Podcast. I am the host, attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So to start, as usual, it's bad news coming from the administration regarding their changes and plans for the immigration system. This guy, Stephen Miller, which is the aide to the president, is really has it out for immigration in general. And as you can tell by the news and discussions that are happening in Congress and by the president and the talking points that they're using. The term chain migration, which I've talked about a lot, is constantly in the news. The psychological impact of the term chain migration is having its effect. It could potentially affect immigration for parents of U.S. citizens, brothers and sisters, and more. There's a fear that they're putting out there that this group has increased amount of crime related to it, which is just really made up. There's always going to be some crazy people, whether they're U.S. citizens, natural born, or naturalized. There's no real correlation as to these programs and their acts of violence, but these demagogic kind of things will always be popping up. One point that I read that was brought up by somebody is that, they start with the push towards stopping illegal immigration, which is the wall and everything, which people can get on board with, but they quickly have moved to legal immigration methods, the ones that are by law in the INA, bring family members, work-based diversity, and their real goal in this, and I didn't really see it as when they were doing this, but it's making more and more sense, is their long-term goal is to just stop immigration. The easy way is to call out people who are here unlawfully or illegal, but they're moving their way, slimily moving their way to cut out lawful immigration methods, bring those numbers down, and eventually probably try to stop it. Now, whether that's going to happen or not, I don't know. There was one of the guys who's actually the sponsor of the Regs Act, which is to stop diversity visa lottery, family-based immigration programs, and the like, made a point in Breitbart's newspaper, I think it was yesterday, that he said if the Democrats really cared about the Dreamers, which is a DACA program, they would have not voted to continue government operations and funding for the government. They would have drawn a line here. And unfortunately, I think he's right. I was under the impression that somewhere or another DACA Deferred Action people are going to find some sort of resolution because there's sympathy by President Trump. There's somewhat national sympathy for these people that came here when they were children. But if there was some backing, it would have happened now when this tax bill was happening. They would have pushed it. And so that not happening is actually interesting. Maybe nothing is going to happen for them. I don't know. It's going to be very harsh to see. I talked about this before. I did a video on people who have deferred action and the consequences, and I was really neutral. I didn't really take a side. I just talked about it. And the amount of hate and trolling that happened to it caused me just to make that video private. Wasn't worth the hassle of just talking about a news report briefly and getting that much hate from crazy people, the things they would say. So there's downright hatred towards immigrants, and I live in Los Angeles. I don't see it that often. Maybe if I move outside the inner city core, or people are, if they were just more straightforward, they'd say it. But the hatred towards immigrants is there. It's kind of like just general racism that's there, but in modern America we don't talk about it. It's just swept under the rug, and it's spoken about in intimate and private groups, but not publicly. And the administration is downright getting dirty. There's talk about them separating children of people caught at the border that are trying to enter the U.S. unlawfully from their parents. So the hope is that by separating the children from the parents, that's going to dissuade them from coming. But that has really harsh consequences. It's going to create a lot of hatred. It's going to psychologically affect these children for the rest of their lives, traumatize them. So I don't know if that's the best program. They're also downsizing refugee agencies and their funding so they can get smaller because they're really trying to cut back on refugee and asylum programs. Also, they're pushing to require more information and collection and gathering and background checks on ESTA applicants, those people who are permitted to use the visa waiver program. Now, this is really important. It's lost. You don't hear this in the news reports, but the travel ban and this ESTA increase in background checks has a primary goal of increasing information sharing from foreign countries about their nationals before they come to the U.S. So essentially the U.S. is creating a massive information collection system that will include all sorts of foreign nationals if they want to come to the U.S. To be able to get this background check, all this information. And frankly, it's a humongous international Big Brother program, intelligence gathering on every individual in the world. So this database, one thing we have to be careful for those who care about civil liberties and just the general structure of the relationship of individuals to the government and how much power they have. Whether you're for or anti-immigration, this sort of information intelligence gathering on a wide scale like this is very dangerous for the freedom of the nation and the country that the founders put together, because of how dangerous it is for have information collection at such a massive scale, really following everybody that's coming in and out of the United States or has some sort of relationship to the United States. Because as you know, if you file for a visa for a person, they're going to ask for family information and such. So there's even more information collection that happens. And it's sort of this worldwide Big Brother program that's being instituted that's very, very risky and dangerous for all of our civil liberties. So that's something to be mindful of, even for people who don't like immigration. There's the idea that this will help in terrorist screening and security. I challenge that. I don't think it necessarily will. Just good police work could have done it. Even when you look back at 9/11, they already had caught all these guys. They knew what was going on. They just didn't do the second and third steps. For some reason, who knows why, the FBI decided not to pursue people who had, flight instructors and people around them saying, hey, these guys are kind of crazy. The FBI should look at this. They decided not to look into it. And it was the same thing with that nightclub shooter in Florida who shot up a gay nightclub. The FBI was all over it. And you frequently see these FBIs already following these people, but then nothing moves forward. So it's a really bizarre situation that having increased intelligence gathering and more difficult immigration, whether visa or non-immigrant visas, won't make a difference when the people enforcing it just fall asleep at the wheel. To add insult to injury, there are reports of ICE even arresting and detaining U.S. citizens thinking that they may be here illegally, and that's just the worst. If you're a U.S. citizen getting detained, it's so difficult. What are we going to do now? Carry passports around and naturalization certificates not to be abducted by these government agents? It's very dangerous, and it's going to lead to a lot of lawsuits, which they'll win. So it's going to cost ICE a lot of money, but should be used in better ways than just paying off lawsuits. So if the officers were just a little more careful and cautious, that would have been avoided. Now, for us practitioners, you all have probably dealt with this. Increased RFEs and notice of intent to deny. I talked about an L-1 RFE I got a month ago for an L-1 that asking for documents we had already provided. Sent the documents in, case was almost immediately approved. And I said in there, I said, listen, we already provided this, I'm just sending it again, and it was approved. Now, it should have been for 3 years, only approved it for 1 year, which is frustrating, but we just took it. Company is fully functioning, operational, good company. It'll get the extension, but all it did was, cost my client more in legal fees and hassle of doing the extension. So that was really unnecessary. It's a great company. It's really good for the U.S. to have this company here. So these kind of things are just so frustrating, the mindset that to challenge and create problems for these people. Now, a quick note. In that case, I argued both they're an executive, which is what I usually always do for smaller companies, but because of the new AAO decision about functional managers, I also said, listen, I know it's not legal and it's not proper to say they're an executive and management, part this, part that. That's not allowed. But based on the AAO decision of what a functional manager is, this person is an executive in charge of a certain function of the company, so they also are functional managers. You know, I'm not saying they're both managers and executives, but based on definition, they fall under both. So one way or another, this has to be approved under one of those. The reason I do this is because when you see denials and AAO decisions where people are denied, the AAO goes back and analyzes the case both from executive and as a manager, including personnel manager as a functional manager. So I'm like, I want to have this on the record, so if the executive part is denied for whatever reason, even though it shouldn't have been, and we go to the AAO, they have that backup telling them previously that, listen, the functional manager works as well. But thankfully it was approved, although for 1 year, which is frustrating. But I also got an RFE for a B1, B2 extension requesting that we submit the personal letter from the applicant saying why they want to extend the visa, and we had already sent this document. So after 5 months of waiting, we get an RFE. And, you know, I get that RFE email from USC that said RFE is coming. It took like 8 days for it to actually arrive, and I was really frustrated because I'm like, I did everything. I mean, if it was denied, it was denied, but like, why are they RFEing it? So like, I got the RFE, I looked at it, and like, you didn't send the personal letter, and I got so frustrated with myself, like, how did I forget to do this? So I go back to the computer, look up the scanned copy of the file that I get, and I'm like, wait, the letter was in there. What are they doing? So I resubmitted the RFE last Friday. It got to them, and include a new letter and also reference the previous letter to say, listen, we sent this, I don't know what you're saying. So we'll see what happens with that, but it's still frustrating. It's additional time, additional mailing fees, it delays things for no reason. It just makes everything frustrating when it doesn't need to be. Now, we just had comprehensive tax reform. I'm not sure how comprehensive it is, and who knows what was actually written in there. Just like all the bills they passed that are gajillion pages, who knows what's actually in there. But talk then moves on to, is comprehensive immigration reform going to happen? And the reality is, no one knows. And my personal belief was that whatever tax bill wasn't going to happen, because it's so hard to move these big bills that have so much financial consequences. There's so many different interest groups that getting something like that passed is difficult. That's why I thought tax reform and immigration reform were never going to happen. Well, tax reform happened, so maybe immigration reform will happen. Now, there's a lot of talk of tax reform because it's such a big bill, because it was written like overnight, some parts of it. The real consequences of it aren't going to be known. And I think immigration, if it does happen, are going to be the same, where we're not going to really know how it plays out. Immigration, you know, I'm not a tax attorney, so I don't know what taxes and all that situation works. I would imagine if I read the immigration bill, I'd know, but you know how they write these things. They say paragraph C of D, section 8, the period is going to turn into a comma, and we're going to delete line 4 after the period. Or they have these weird things. It's very difficult to grasp how the big picture happens, but it's probably going to be a lot of the same if it does happen. Now, I personally don't know how immigration reform is going to happen, because immigration is such a massive program. Programs of different visa categories, each with their nuances, each with their pros and cons. To sit and fix every one of them, it's going to create so much hostility from various groups that it becomes hard to push back on it. So I don't know what's going to happen. I just hope it doesn't become more restrictive or more onerous, which in practicality, execution of it is, if you know you're getting these RFEs, if you're getting requests for more information, if the slowdowns in the cases are happening. Now, for example, the Entrepreneur Pro program, which was created by President Obama but wasn't supposed to come into place until next administration, was shut down by this administration, has come back now, but who knows how long that's going to be, because these people don't have an interest in continuing that program. And furthermore, if you read the instructions, and Ayla did a follow-up notification to everybody that the instructions don't match what the law is, so there's errors in there. So who knows what's going to happen with that. It's debatable whether to file for that, because maybe you file for it, spend the money, and the program doesn't happen, or they just delay approving it until some situation happens where they cancel the program. Because the court case that caused the entrepreneurial program to come back online was kind of dubious. They said they didn't give, I think it was that the government didn't give enough notice for people to like talk about it, so they have to reinstitute it. So essentially the government just give another notice time and just say never mind. So it's not a really reliable program unless someone just wants to take a gamble on it. And it's interesting because, you know, tax reform, immigration reform, these are hot topic issues. Not much tax, but for immigration, this is one of those issues like LGBT and gay marriage and stuff, where it's a great political football for politicians to use to get votes. So, you know, they just take a side and harp on it and create speeches and that kind of stuff. Not because they want a resolution to reach their goal of whatever they say the goal is, but because it gets people riled up. It's like things related to the flag and that whole football fiasco about kneeling and not kneeling and you know, standing up and all that kind of stuff. And just like gay marriage, they milked that for probably a couple decades, but really a hardcore 10 years, challenging it to get votes. Eventually it was passed and that kind of subsided, but immigration is another one of those. So they could probably drag this around. I bet the politicians don't want a resolution of it because it does create so many votes and points for them from their sides and fundraising, just bashing either side of it. So it's so hard to see what's going to happen. The politics are so crazy. And pretty much every other day I'm getting emails from people asking, so what's going to happen? What does the travel ban mean? What does this mean? And I said, I mean, what's going to happen with it? And I tell them, listen, like, I'm not Nostradamus. I don't have a crystal ball. I have no idea what's going to happen in the future. All I can say right now, for example, the travel ban is, you know, if you're getting married to a foreigner, if you're going to get married, you might as well file the I-130 with USCIS while it's allowed. And then at the MVC stage, we just wait to see what happens. Hopefully some waiver stuff happens. Now that's a good transition. I talked about this because, as you all know, the circuit courts are challenging President Trump's travel ban, but the Supreme Court's decision that the full travel ban be in place until like they make a final decision, hopefully next 6 months, is going to stand. And so denials are happening. Now here's the interesting part. The law, I mean the so-called law, the executive order says that the foreign national has to demonstrate to the consular officer or CBP official to their satisfaction that they meet the waiver standard. So if they apply, it comes under the waiver, like whatever waiver system is, and it's not really explain how the waiver is supposed to be presented and all that kind of stuff. But it does say the foreign national has to demonstrate it, and there's 3 prongs to it, show like undue hardship, and it's in the national interest, and all this kind of stuff. The issue is, right after it happened, denials started coming out. And there's different types of denials embassies are issuing. The paperwork looks different. But essentially, on their own, a lot of times, they're just issuing a denial. So I have people that call me that were in administrative processing from Iran for like a year. They emailed the embassy to say, hey, what's going on? And the email responded with a denial notice saying, we reviewed the waiver, you're not eligible, deny. And these are people that do EB-5s, marriage-based cases, fiance-based cases, and tourist visa, which was, I would have assumed would happen. So this is really catastrophic because the embassies are taking control and doing things that doesn't match the executive order. They didn't allow the foreign national to demonstrate that the waiver is applicable. On their own, they're denying these. So how does that happen? You go to LegalNet to discuss that? Who knows? If the Supreme Court goes and undoes this whole situation and says the travel ban, at the very least for immediate relatives or people with some sort of interest in the United States, are okay, what happens then? Do these cases get reopened? They're at the embassy. Do they get sent back to USCIS and sent back? And you all know when a case is denied at the embassy and sent back to USCIS, that's an automatic year at least of waiting, backlogs, all sorts of issues. So it is very catastrophic for families and people that are waiting, investors that are waiting. It's just a horrible situation. And frankly, now I went back and read the executive order on purpose because I want to see if the embassy has to wait for the applicant to demonstrate the waiver reasons. And they're denying it on their own without that demonstration, without that affirmative demonstration by the applicant. So that's a big deal. That's one way potentially to go to LegalNet and challenge these denials. Definitely talk to your clients and spread the word. That may be the way to go about it right now. But who knows, as you know, consular processing, they do whatever they want to do. So it makes it really hard. To add to the insanity of the immigration process, the EB-5 program, regional center basis, has got another extension, I think, for another couple of weeks. And it's just turned into a joke. How do you have a program where foreigners that are millionaires and billionaires investing $500,000 to $1 million or more in the U.S., the program gets renewed every couple months and the can gets kicked down the road, and there's no finality to it. There's no like reliability to it. If some person comes to me for a consultation today, I can say this is the rule today, but it could change tomorrow. I don't know what's going to happen. How is an investor going to make a decision? And they do because they have to. But it's a terrible way for people to have confidence in the United States and the whole system internationally. And this kind of goes down to the President Trump's trying at least to destroy the Iranian nuclear deal that's with the European countries. You know, if we just make deals and then break them, have rules that change every day, it turns into some banana republic fake kind of system that people can't rely on. And that is the most dangerous thing, and along with the faith and civil liberty stuff I talked about earlier, it's just a general lack of confidence in the structure of our political system. If people could willy-nilly change rules on a day-by-day basis, sign executive orders that just change things and spy on people, and have rules that get extended every couple months, but there's no finality to it, it'll get to a point where people don't have confidence, and that then goes into the economy where people are like, well, I can't invest in the U.S., even American citizens, because tomorrow the tax is going to change without me knowing it. I buy a house, the interest payment on it is not going to be tax deductible. Also, I'm paying more, which I couldn't. These have prevents long-term investments, both money-wise and personal. So if someone goes to school with the idea that they're going to get a certain job, and when they graduate they're going to make money in that job is going to be there, it's not going to have insane taxes on it or the regulations, they can't rely on that. And what happens in societies like this, and the best way to see what happens is societies that have high inflation. And that may happen to the U.S. And inflation is, frankly, an increase in the money supply, which causes increase in prices. Usually people see inflation and price increases. And that's when people stop having faith in the system and faith in tomorrow. And when that faith is lost, it's very hard to bring it back. What the consequences are, people only live for the day, and that's when you see drug and sex abuse really rise in societies. And you see this throughout the world in countries that have high inflation. People just don't care about tomorrow and live for today, because the value of their assets and their investments and what they put their time into is dubious if it's going to be of value tomorrow, so they live for the day. And I mean, you see that in the U.S. and medical care inflation, in education costs, and all sorts of other things that pop up, rent. This is really coming, and a couple of factors here and there changing could slam the U.S. with really high inflation rates, and we'll see the whole system really collapsing in on itself. So it's a very dangerous situation, playing these kind of games willy-nilly with the whole system. I mean, this is a huge multi-trillion-dollar system. To just randomly change stuff and make decisions on a whim without thought and without some slowness to it. It's like doing a right turn going 90 miles per hour. The car is going to spin out of control. You got to slow it down to make the curve, or just have a huge curve so you could go fast but go away. Even if it's things that you don't like about the law in the system, fast change, what I've realized in my studies of political science, is never good. If you look at almost every revolution in the history of the world, except for random sporadic ones, maybe the U.S. Revolution, back in 200 years ago, every time there's a revolution or rapid change in the system, it only gets worse for the people that were under that system. It never gets better. So a lot of time, the devil is better than the devil you don't. And no matter how bad the system is, frankly, it's always better to stick with what you have, because the alternative is always going to be worse, almost always going to be worse. And that's kind of depressing, and I hate to say it that way, but it seems like the reality of what we're dealing with. Now, the Trump administration, I read on one website, and I forgot to write the name of the website down because I'd never heard of that website, but they said the Trump administration appealed the work permit for H4 spouses of H1BBs, the H4 category, their employment-based EADs. Now, I don't know if that's true or not, because this website I never heard of, and I tried scouring the internet to see if there's other sources, but they said the Trump administration got rid of the H4 EADs. I don't know if that's true, but in the article when I looked into it, it had some facts that they allege, and says the rule specifically allowed H4 visa holders whose spouses were waiting for a green card approval to get jobs in the United States. Quartz reports, and Quartz is one of these websites, that the majority of the H4 visa holders are Indian women. 80% of the 125,000 H4 visas issued in 2015 were to Indians, and 90% of all H4 visas were to women. So the women part I kind of assume, but the fact that the Indian nationals are the vast majority of people that are getting these visas. Very interesting little fact that I thought I'd share. And one last note, there's been a lot of reports, especially in a travel ban, that the global entry program was being canceled, the privilege being canceled and revoked by a lot of people that are Muslims or from nationals of certain countries. There are lawsuits now happening over this, because overnight people are coming with the global entry program and it's not working. So if you have a client that's dealt with this, go online. There's probably class actions that are happening. Definitely follow up with this, because if there is cancellation, it should be told what the reason is, not just willy-nilly them canceling it. If it is because of travel ban or you're from a country, if that's the case, it should be told. It shouldn't just be overnight without any due process or reasoning, just canceled willy-nilly. So that's interesting. Oh, a couple more practice notes. There was a congressional bill, actually both in the Senate and in the House, that's trying to fix the mail delivery system for USCIS, especially when they send you priority mail, the green card in there. There's trying to add a system where you pay more and it'll have like signature guarantees. You have to sign before you get it, because these things are constantly getting lost in the mail, and it's such a mess to get those resent or do an I-90. They're also potentially allowing the post office to hold on to them, so you can do physical pickup instead of having delivered to your home. So there's little interesting things that are happening, and hopefully they'll be able to pass to help a little bit to avoid the mess that it is when the green card is lost in the mail. Another practice pointer for I-751s, the Form I-71, it was updated. I did a quick glance for the application for removal of conditions for married green card holders. I'm not sure what they changed, but they have updated that form. Also, they updated the definition of economist for NAFTA visas. It's going to be more difficult. They're not going to include, what was it? A financial analyst and stuff under the economic model, even though it should, it makes perfect sense, but they're not. The TN is another one of those areas they're going to go after. Frankly, it's getting frustrating doing TNs because, I usually do Canadian TNs, and people go to the border, and the border officers could ask for whatever they want, no matter how much documentation you send. And so it becomes such a hassle. I have to over-prepare TNs so much, and that increases fees, and it's frustrating, and the person goes there, they're afraid, and who knows what the officer's going to approve and what they're not going to approve. So I'm getting to the point of like, do I even want to do TNs anymore? Because I have to like charge so much, and I know like it shouldn't be that much work, especially when you have like straightforward TNs like an engineer or something like that. But you get so much hassle that you got to like spend so much time prepping what the company is, what the work history of the person is, prepping the client for the interaction at the border, that I'm trying to push people to do USCIS filing for TNs, but that's a little bit of a hassle because you got to do pre-em processing, because who knows, I once did a TN extension that wasn't pre-em processing. It took 6 months for them to approve it. That was very frustrating. And so even with the USCIS approval, if they go out and they want to come back in, the CP officer has to review it and look at it too, and they could cause problems deny it too. So TNs are just such a hassle unnecessarily. It's supposed to be an easy program, but unfortunately things are happening that way. Now it is the end of the year in December, and I'm taking a personal look at what happened this year in my practice, and some things I thought about, and it's interesting for y'all to think about for your practices too. First and foremost, I have a benefits-based practice that's primarily with USCIS, so I do family cases and employment cases. That's the bread and butter. That's the majority of it. So I looked at what types of cases I've been doing this year as opposed to last year. Last year I was doing like 50% business, 40% family, then 10% naturalization, I-90s, I-131s, that kind of random stuff. This year it was like 70% marriage cases, 25% business, and small amount of other kind of cases. So it was really interesting how it went. Last year I was on the verge of stopping doing marriage cases because they're kind of time consuming with the couples and stuff, and business cases were so high. This year it's switched up where business cases were lower and super time consuming when I did do them, but marriage cases were higher. So like maybe I should just do marriage. So it's just so random how it changes every year. But one thing I did note is I-90s and I-131s are supposed to be very simple applications, but the few that I did this year took so much time getting the reentry permit or the renewal. So many issues came up. The clients required so much time talking about it that the little I charged for their simple application just wasn't enough. I have to charge so much for those and raise my fees for those that it's debatable whether I should even do them, because a client comes to me and I want to do a reentry permit, and charging that high a figure because I know how much the client's going to want to ask questions, because the clients that did have a reentry permit were so paranoid. They kept calling me asking when to file, when do we get the because it's one of those things where reentry permit, they come to the US, stay here for a month to file the case when they're here, do the fingerprints, and then leave, and then later on get the green card. But their paranoia and the amount of hand-holding that it required made it really a loss for my firm to be able to, or myself to be able to take care of these cases. The same thing with the I-90. I had a case where the applicant was older, his fingerprints didn't work, and we had to get police reports. In LA, it's really difficult getting police reports for somebody that can't do biometrics. LAPD won't issue it. Had to get LA County Sheriff involved. LA County Sheriff took so much time to fix it and do it. Really, like, it was such a loss for me to work on that case that I'm like, I didn't want to do I-90s. Like, do it yourself. It's just not worth the hassle and the time, because I have to charge a lot of money, and then my client sees the I-90 and they're like, you're charging this much to fill out this form. They're going to think I'm some sort of like bad lawyer that's trying to take advantage of it, but they don't understand the reality of how time consuming these things could be when they blow up in your face. Now, that leads to the next thing, is when these issues do happen, RFEs, what to do. Now, I had a policy of flat rate of not charging for RFEs, because I used to think like, well, if it's an RFE, it's my fault. But it's almost never my fault. It's for the last couple years, it's always USCIS asking for stuff that they don't really need to. That's almost always the case. Or before I tell the client, you have this issue, you're going to get an RFE. If you want me to go file, we'll be prepared, but I wouldn't charge for that. But that's a very foolish thing now that I see, because it takes so much time to respond to these RFEs that I have to start charging for that. And I was reading one listserv. One person had an interesting thing that I'm going to implement in my contracts is adding time. So once we file the application, the legal work is done. If the client wants to call and talk to you, that's a separate hourly fee, or actually this is going to happen. Give like 5 hours of time after application submission. This is for business cases. For marriage cases, that'd be much less. That allows them to call you, ask questions, or if the RFE, handle that. But once it goes past like 3 or 5 hours, then the hourly rate comes in. For a marriage case, that'll be like, after we submit the case, 45 minutes, an hour of quick follow-ups or whatever they need to talk about, asking about when the EAD comes and that kind of stuff. Small things, or following up with USCIS on phone calls to see what's taking the case for so long. But after that hour, then it goes into the hourly mode. Now, vast majority of cases don't require more than an hour of follow-up time after the initial application is submitted. Now, if you're going to go there interview with them, I charge a separate fee for that, for the interview preparation and attendance with them. But when it comes to just the application, their follow-ups, their worries and stuff, having a pocket of time is free, but after that charge seems to be a way to go, because there's so much time that goes into this to follow up sometimes the RFEs, especially when it's not your fault and USCIS being difficult, that it just becomes not worth it to do the case, or it requires you to like get slammed. You have a deadline for other cases, you're busy, then you get a stupid RFE that costs you 10 hours of work, and all of a sudden you're up until past midnight working on cases, and it's never good to be working on a case past midnight unless you're a night owl. But to be doing these kind of important, lawful things on a rush like that. So that's something to be thinking about for your own cases, for RFEs and office planning for the future, and how to deal with that. In general, with the USCIS difficulties, with rising costs in various ways, your legal insurance goes up, the post office fee constantly goes up every 6 months. You got to raise your fees, and I'm going to institute a fee increase for my consultations, and I'm going back and forth whether to do that or not, but probably there's going to be some sort of fee increase for that. And I also went back and looked at all my cases, how much I charge for marriage cases on average and stuff, and there's a step up in fees that are going to happen in that as well, because just things require more time, and my service is getting better, and my education experience is getting better, and there's a value that comes with that. The fact that I spend so much time studying all these cases, that goes into what the fee is. Having a lawyer that spends a lot of time studying and being aware and going to all the meetings and conferences and writing USCIS and participating in AAO, all that kind of stuff. It just has to happen, because you get what you pay for. You're getting paid for quality. And if you're watching this podcast, that means you care about your podcast and you like thinking about this stuff. You got to do the same. You just can't sell yourself short like that and get paid peanuts, because the work we do is stressful, and frankly, immigration attorneys are not the highest paid attorneys out there. So you got to get what you got to get to pay off the student loans, housing, all the expenses you have. Don't be shy about it. You deserve it. If you're a good attorney that cares about your clients and spends a lot of time on education, continuing education, and a lot of time on customer service, you deserve what you get, if not more, because there's so many bad attorneys that don't do that, and you see it every day. Frankly, this year I got so many cases that used to be at other firms, and big firms that have really famous names and huge reviews and are really wealthy, that their clients just came to me. They couldn't stand working with those people anymore. So this is the reality. If you're giving good customer service and you're on top of your game, you deserve whatever you can get, and the more the better. One last thing about office management, and I do all my cases myself. I don't have staff, but as I say all the time, I realize whenever I have to deal with more than 3 or 4 cases in a day, it might even be quick emails to random clients, I get really worn out. It's like the other day, I had 8 different cases where I have to follow up and do this and that, and by the time it was all over, I was just exhausted. And I realized my brain doesn't like to switch up, and I think this is more for male than females. Men have a narrow focus, whereas women are better at multitasking, and that might be a generalization, and it's not offensive, but as a guy, I gotta limit how many different things I think about, especially with my cases, on any given day. And I have to let my clients know that, because I try to give immediate responses as possible, but if I see I'm touching upon 3 or 4 medium-sized complicated issues where I got to think about something and switch my brain, that has to be the limit. I can't go past that unless there's some sort of emergency, because it's way too draining for me mentally. Also, I published an article with Ayla. The document number is 171-21562. It's called How to Learn and Keep Up with Immigration Law, and it goes over a lot of the ways I keep up with everything that comes with immigration law, what sort resources I use, one of my primary sources, all this kind of stuff. Again, the Ayla doc number is 171-21562. It might be an interesting read, especially if you're new to immigration, to help you get a handle on it. When I first started, I worked for another immigration attorney, and that was my only source. So whenever I had a problem, I would read the I-130 instructions, or I would ask him for help, or sometimes go on Google and stuff. But then when I started my own practice, I realized I got to go down to the primary sources. I got to read the INA and the CFR. I got to read the FAM. I got to read the Adjudicator's Field Manual. I got to go to those primary and secondary sources in court cases when I make a decision. I can't rely on my friends saying this or a colleague saying this, because they could be wrong, and I've seen it happen when they were wrong for myself and other people who relied on bad information. At the end of the day, you signed that G28, you're going to be responsible for that error. So always go to primary sources, and I break down what I do, where I go, and all that kind of stuff. I also want to give a shout out to Arya, a new listener who found me actually based on a podcast I did about abandonment of lawful permanent resident status. It's a really detailed breakdown of all the rules and court cases regarding abandonment of status. He reached out to me. It was very good speaking with you. Thank you for listening to the podcast and continuing listening. And if you're interested in abandonment of status and all the court cases, that's one of the podcasts I did from last year. I can't remember what number it was. Would have been good to write that down. One last note before I go to some AAO stuff that was interesting is there was the quarterly CBP meeting with LAX happened, and it's always fun. There's a lot of bad blood with CBP, but frankly, the higher-ups in CBP at LAX are all really good people, and I have a really good relationship with them, and they're really cool. So if you have these CBP liaison meetings in your area, districts or whatever, try to go to them at your major airport and talk with them. They might be good people there too, and you can have a relationship. You have their emails and phone, and they can really help your clients there. You could ask them for guidance, and they're just there for you. So it's really good. Two little points I thought would be helpful, and I've talked about this first one a lot. Sometimes if applicants or a foreign national who's a lawful permanent resident, green card holder, they'll have an expired green card and they're overseas. They're fully permitted to board a plane and enter the United States. However, because the airlines are afraid of the fines that could happen, which are in the thousands and thousands of dollars for letting someone enter the United States or board a plane to enter when they weren't, a lot of times they don't allow you to get on the plane. So first of all, they're fully allowed to get on the plane to come to the United States. Now, if they have a stop in some countries require transit visas. But that on their own, the airline is supposed to let them board with the green card even if it's expired. If the airline doesn't allow you to do it, there's a program called the Regional Carrier Liaison Program. And I said this before, but it's really important. The Regional Carrier Liaison Program. And the airline people, and a lot of times they don't even know the program exists, but the airline people could call this, and it's CBP essentially. CBP gives the clearance to say, no, these people are okay, and allows them to board. So that's something very important to tell your clients, and remember that the Regional Carrier Liaison Program is the way to go. The other thing is about automatic auto revalidation, or is that what they call it? It's when someone has some sort of status in the U.S., they came with a visa, the visa expired, they could go to Mexico or Canada for what is not a meaningful departure, a short time, less than 30 days to come and go, and they could go and re-enter. That's an interesting program. But when it comes to things like the E2, so someone gets an E2 visa, it's valid for 5 years, their status in the U.S. is only for 2 years. And to renew that 2 years, the thought is, you just hop over to Mexico or hop over to Canada, come back in, and that gives you a whole new 2 years. Well, the reality is, if there's no meaningful departure, meaning you go to a short period of time to Mexico or Canada, that doesn't reset the status period for an E2. You just go back whatever time you have left. You have to either go to one of these other countries outside of Mexico or Canada, or stay in Mexico or Canada for 30 days or more, probably more than 30 days, to have meaningful departure, and then enter to get the the full 2-year re-status for an E2, for example. So that's something very important to know so your clients don't get stuck outside. Now, going to AAO cases, I was reading one about adjustment of status, and this kind of interesting case is kind of weird, so stay with me here. This guy's in the U.S. On a student visa, finds a job, goes back to his home country, I think it's Syria, to the embassy to do an H-1B visa, gets the H-1B visa, returns to the U.S., However, that company never starts or falls apart, and that person is here on lawful status for more than a year. So the 10-year bar applies. They eventually get TPS. With the TPS, they get advanced parole, and they find another H-1B employer. So they use the advanced parole to go to Canada, get the H-1B visa, and then return. Now, this person ended up being a doctor and had an employment-based case for, I can't remember exactly how it was, but something where they needed to be a doctor for 5 years in a rural area, and eventually they could get a green card. So they applied for adjustment of status. Now, the AAO says the case would be denied anyways because it'll be another couple more years before the person can apply for adjustment of status, so it should have been applied anyways. But one of the other reasons USCIS denied the case, which the AAO took on, was that, you know, when they did advanced parole and they left the United States, USCIS said they should have re-entered with advanced parole so that they wouldn't incur the 10-year bar. Because when you do advanced parole, the idea is you're still sitting at the border on the U.S. side and you never left. That's the legal fiction that they use. But by re-entering with the H-1B visa, the departure was okay, but the re-entry was not proper, so the 10-year bar applied to them when they re-entered, and that was going to be a problem. They appealed it. AAO said no, actually. USCIS made a mistake. The key is the departure. So if you depart with advanced parole and you re-enter, you didn't leave the country and the 10-year bar doesn't go into effect. So that's a very important issue for adjusting status. Now, I'm not sure how often this fact pattern comes out, but it was an interesting little thing to know if you're into immigration law. For advanced parole, that departure is what counts to see if you keep yourself away from that blasted 10-year bar. Now I'm going to go into some L-1 and EB-1c stuff, so if you're not into business immigration, I'm ending it with this, feel free to tune out at this point, but I'll go over some fact patterns that popped up. So the first case is matter of H-USA. And this case is an L-1 case for a Chinese company, and the issue is about ownership interest in the company. And if you do L-1s and EB-1cs for Chinese, you see this problem. China doesn't have a system like the US has where they register percentages. And I think even Russia has this, my Russian cases, where if you own a company, you could have an official registration of how much you own in that company, or who the owners are, who the managers are, all that kind of stuff. And China doesn't have that. And in this case, the person that filed the case has said there's no qualifying relationship because we can't show ownership and control. The applicant said we have a statement from the accountant explaining that China doesn't do that kind of stuff. And they said, the AAO said, however, the reference statement is incomplete as indicated by the fact that it stops mid-sentence. So they did a terrible job writing that statement from the accountant, and it's missing the signature page, so that was ridiculous. And they said no other evidence was provided to support the claims made by the foreign entity's accountant regarding the ownership of the foreign entity. So what I do with L1s is, you know, they have an operating agreement in China, you know, internal operating agreement that specifies the interest of the Chinese company, who owns it, how percentage and stuff, and we submit that and it works. But I don't like it at all. I wish there was something more tangible showing ownership interest. Like in Russia, as I said, they have some sort of government registry that breaks down ownership percentage and stuff. And frankly, in the US, we do LLCs. We do send a managing member report for California, something like that, but it's the operating agreement that lists the ownership interest. So, you know, that's the case here too, but I just wish there was some sort of government breakdown on what the ownership interest is. It would make this much easier, because who knows, USCIS might have a problem with that, even with the operating agreement that they have in China, and then what are you going to do? How are you going to come back from that? The next case is matter of H-N-A-LLC. And this was a general denial of the case by USCIS. And AAO didn't really specify what the problems were, but they overruled it. They say, you know what, the applicant and the petitioner had submitted enough information to prove this. They didn't really get to what the facts were that they thought was insufficient or not. But it's just important to show, a lot of times, this happens unfortunately more and more, the initial petition is a good petition, but it gets denied by USCIS. And sometimes you either have to refile it, or if that's not a good situation, you got to do an AAO appeal. And the AAO will look at it and fix it. These things do happen. So don't be afraid of filing the appeal. If you feel that the case is solid and it should have been approved, that might be worth doing. And sometimes it happens pretty quickly. I've had AAO cases on EB-1A cases where it was denied 2 times. And we appealed the AAO, and one was the L1 actually was denied. And within like less than 2 months it was approved. You know, I read all these AAOs, sometimes it takes like a year or two for AAO to get to it, but all the AAO decisions I've ever made were approved like this, within a few weeks to a few months after it was appealed. So it's definitely something to look into. The next case, and I forgot to write what the full name of the case was, but essentially it says this part-time status and intermittent time in the U.S. on an L-1A is okay. It's, you know, sometimes practitioners are afraid to do this, and I've seen USCIs push back on this. But in this case, the foreign national that was the employee was the CEO of a company, had multiple offices, you know, in Finland and somewhere in Asia and in the U.S., and they would come once in a while to meet in the U.S. and go back to Finland. Intermittently, they'd be in the U.S. They would maintain, the applicant here said they would maintain residence in Finland, intermittently be here, and the U.S. petitioner does not currently have, they went on record with this, the petitioner acknowledges that it does not currently have a reasonable need for a full-time, year-round CEO in the U.S. based on its current stage of development, and emphasizes that the regulation allows for L-1A beneficiaries to work in the United States intermittently. Now, this is a company that had $3 million in sales in the first year, and the AAO made this point that this isn't some fly-by-night kind of thing. And that the director erred, and I like the way they say that, the director erred by not considering the petitioner's claim that the position requires intermittent physical presence. So that's something to note. Sometimes your applicant can't come here, it's got to be part-time. Sometimes their income in the U.S. by petitioner is going to be really low, and you're afraid that the USCIS will say, oh, how's their salary so low in the U.S.? You say, well, they're part-time. You can mark, that box is there on the I-129, so you could use part-time. Now, I prefer not to. You know, you could just submit it saying they are going to be here full-time, but then when it comes to extensions, say they came intermittently. But that is allowed, so that's something to use when you need to, depending on the case. Now, another case came up, it's called Matter of W-Corp. And in this case, it was an L-1B beneficiary who came to the U.S. A job changed where they were going to make it from L-1B to an L-1A functional manager in the U.S. And they filed the extension plus a change of like specific kind of status. USCIS denied it because they went back and said they didn't prove they were a manager back home. Now, they went into that kind of detail. Wasn't necessary. You could be an L-1B, come to the U.S. and change to an L-1A. That's not a problem. The issue is when you want to do an EB-1c green card, you have to have been a manager back home. Now, this is really important. L-1Bs, a good amount of time, it overlaps with the functional manager. Because functional manager is so vague and the definition was so bad where the AAO had to do a revised explanation of it, which still isn't that good. Sometimes it's better to an L-1B because it's easier to explain than a functional manager. But always keep in mind that that could be changed, and challenge USCIS. If you're just sticking with an L1 and you don't plan on even seeing it, if they're a L1B abroad, they can be an L1A in the US. That's not a problem. And you could go back and say they're functional managers as well. Just make sure. So when you do an L1B, there's a potential it's going to be E1C, and the facts allow, you can't just make up anything. Prep that initial case for an L1B with the backup evidence and explanation of job duties that also applies to a functional manager. So later on when you go and do something, you could go back to original document and application or petition and say that, listen, we said it here, it just, for the time we need L1B and specialized knowledge was easier to explain, but in fact, when you look at what the person was doing, the kind of work they're doing, and everything that's associated with it, that was a functional manager. So that should be cool, and the EB-1c should be cool. Now, it's hard. It's going to be hard, but it's completely valid. Just make sure you prep it. You don't say the wrong things to the L1B that makes it look like they're not in some sort of managerial duty, and so that's going to be very important. The next thing is matter of S.I.Inc., and this is not too long, but I just want to make the point. When you're doing L1s, EB-1Cs, and this is what differentiates a person who does these a lot or studies a lot, is you got to be very careful. For L1s, EB-1Cs, USCIS officers, adjudicators are looking for one single word that will get you. And if you're just off a little bit to make it sound like a manager is actually doing some day-to-day work, they'll just straight up RFE it right there, and it's an uphill battle. When you're writing the job letter explaining what the person is going to be doing in the U.S., you got to be very cautious and very specific that there's no day-to-day activities in there. It's all managerial. And here, they in this case, they wrote like the person coming is going to be assisting and supporting. That assistance words didn't help because like what? You're a manager, you're going to be assisting people on a day-to-day basis. It's kind of nonsense. And then it says includes training workers. Well, you know, managers doesn't necessarily train workers. These kind of things will get you. So they say the emphasis on the beneficiary's personal involvement in training undermines the assertion that the beneficiary primarily perform high-level responsibilities. Now, unfortunately, this is really stupid because, like, you know, Warren Buffett goes down and sometimes needs to train managers or train lower people or do some stuff. In Amazon, I think every employee in Amazon, even Jeff Bezos himself, has to go be a phone operator once a month or once a year so they can get down to it. Now, there's some sort of training that's going to happen. There's some day-to-day work. They should be flexible on this, especially if you say, you know, that aspect of their job is only 10 or 20%. But they'll pick on it. And once they pick on one thing, it's going to open the floodgates for that problems with other stuff just to back that up. So you got to be very careful to get that L1 in, to get that EB-1c in. Be cautious of the language you use. You can't use willy-nilly, just whatever kind of wording, because that's what they go after. U.S. adjudicators are looking for just one word to get you and RFE you, and that's the wild jungle and dangerous zone that we're dealing with to doing these kind of cases. These applicants and petitioners are spending sometimes hundreds of thousands and millions of dollars they have to spend to get the company here. They're paying you a bunch of money to do it, and it gets very risky when you don't pay attention to every single word. It can happen to anybody. Sometimes they interpret words differently than you, so there's no golden ticket, there's no 100% protection, but that's the situation we deal with. And one thing I've been getting this month, you know, one of my clients left this like wonderful review about an L1 case I did for him. Worked really hard on that case, took 65 hours to do it. It was just intense, but I got it approved. And after that review came online, I've just been getting L1s a lot after that. And I keep getting L1s that are denied from other people or RFEs from other firms. And some lawyers that are well-known lawyers that like I respected and I follow all kind of stuff, I'm seeing the work they did, and it's just horrible. So you never know who's a good L1 attorney, who's not, who cares enough to pay attention, who's not. And also then when it comes out to what kind of fees they're doing. And frankly, their fees are like a third of what I charge. That's some big firms, some well-known firms. The L1s are you're not supposed to talk about money and stuff like that. It could be, you know, trade issues of price fixing, all that kind of stuff. But they're in the lower thousands. And L1s require so much time and attention and so much attention to detail, talking with the client, reviewing it, and it really should be done by the lawyer, because the paralegal shouldn't be doing that kind of intense legal work. That when I see what these firms are charging, these minuscule amounts, they're probably doing high volume on the L1s, but it's like you can't do a good job. It's of course they're going to get RFEs. Of course these cases are going to deny. When someone charges a couple of thousand for an L1, which requires like 65 hours of legal work in that one case I just had, and at least 40 hours for a good, well done L1. I mean, these are new office L1s and small office L1s I'm talking about. If you're doing, you know, Disney and MGM and IBM, where they're doing blankets and the person has 10,000 people underneath them, yeah, you could charge lower amounts because a lot of the work is already done. It's more simpler to explain rather than a new office L1. But even those, one of our colleagues at a big firm I was talking to about the RFE, they had a case where the L1, a person had 10,000 employees underneath them, and they RFE'd him saying, how do you prove that they're a manager and executive? So that kind of nonsense does happen. But when it comes to these new office and small office, it just doesn't fly. And it's hard for applicants to understand this, and there's a lot of time they're like, you know, Indian L1s that are coming here, they're price conscious about this, but the reality is, like, if you want good service, a couple $1,000s for L1 is just not going to cut it. A lot of firms are going to charge that much, but it doesn't make sense because you're just going to end up with a denial. And you just got to, for example, a new office, you just lease the place you're spending a bunch of money on, and you just wasted a 6-month lease or a year lease because your L1 was denied. So the consequences are really harsh, and clients, it's hard for them to understand this necessarily. But it's just important as a lawyer that if you're going to be putting a real L1 time into something, you got to charge a reasonable fee because it's going to drain the hell out of you how much time it requires to do it. I mean, I really get a kick out of doing it, so it's like a lost leader for me. Like, even if I don't make some money, I enjoy the clients when they're serious business people, not when it's like a joke. Some people are just doing L1 just to do it. I really get a kick out of it. I like looking at the corporate documents. I like helping them plan the growth of their company. When I see them grow and rise and hire people and make more money, I really feel like I was a part of it. So I really get a kick out of it. But that's just some stuff I saw since the last podcast. That'll be it for today. I think I've been yelling and ranting for enough. My throat is giving way. Thank you so much for listening to this podcast. As always, you know, call or email me. My email is info@jqqlaw.com. I really enjoy talking to listeners and hearing what they have to say and just, you know, growing the community. I have a Facebook page I created for this, and I've just been so busy that I haven't been able to get into it, to get people to join and keep the conversation flowing so it rotates and we could share information like this in that, you know, Facebook listserv as well as my other listservs that I have. But, you know, keep in touch. I like to grow that stuff in 2018. I have a lot of office and firm projects that I'm instituting, which I'm going to talk about, so hopefully you guys could do the same to, you know, do better marketing, better continuing education, and better customer service. But that's it for now. I hope you all have a great and happy and safe New Year's. Hopefully I'll be back really soon in January to just talk about new events, and hopefully it'll be better news than what we have today. Until then, I'm John Kasravi. Thank you for listening. Bye-bye.